turn on, like,
Yeah, you can leave it on, see if it,
picks up anything?
yeah. Just speak very loud.
Okay. Thank you. Are we ready?
None of these mics are movable. Sure. That's all.
We are live.
Make one.
Let's do that, let's put James up top. When he gets it. No, it's-
Ready?
Yeah.
Ready?
Go.
Okay. Let me turn the recording on. This is just for backup. Okay, we're recording. Good morning. It's good to be here. Today is October 29th, Tuesday, and it is 9:30. And we're meeting at our scheduled bargaining session with the representatives of our police unit, the FOP. And if you would be so kind as to state your name for the record.
Sure. Paul Maniotis for the FOP.
Rose Derrick, County FOP Council.
Sergeant Brian Dodge, FOP.
Angelo Farnbush, District Director, FOP.
And by Jacob Horowitz, the town attorney.
Dave Lynch, town manager.
John Williamson, Deputy Town Manager.
And I'm Lorena Bravo from Bryant Miller and Olive Outside Counsel for the town. I don't know if you're aware, probably Sergeant Dodge is. The town hired a town manager, Mr. Lynch, so we welcome him. He just started under a week ago, and he's happily joined us this morning, and he'd like to make his own opening remarks.
Sure. I sent you a secret envelope with our final offer on everything. You've all read it, I'm sure. Appreciate it. I want to thank the chief and also the fact that Jason is here as well to help us along the way. I am the new town manager, and all I really wanted to say was that, you know, when you all take that oath of office, there's that phraseology, preserve and protect the Constitution of the United States. Phrase, this is Mr. Daverman, our finance director. James, why don't you take a seat up here, and then we'll access you and your information when it becomes necessary. But that concept of protection is, it's actually the number one duty of government. That's what it is. You're the first line of defense in everything, and we like to fix potholes and run festivals on the weekends. But the fact of the matter is that nothing happens without preserving the safety of our community. And so you're not only the first line of defense, but you're the only people that work in municipal government that say, by the way, if I have to put my life on the line, I'm gonna do it. So it's an astonishing commitment that everybody in uniform makes. I began my career as a municipal prosecutor for the city of Cleveland, and my entire environment was working with the police department. My job was to evaluate reports and determine charges that would be issued. And when a police officer had a long night and needed to have papers issued on a defendant that he'd been or she had been wrestling with over the night, they came to my office, we talked about it. And I've tried many, many cases as a municipal prosecutor, and my life has sort of been always in the context of the importance of the police and helping them, because your job is hard enough as it is. It's a very difficult job. You know, we sort of defer to our military, and they deal with a particular issue here and there, and they're not sure what's gonna happen over in the Middle East. But I learned a long time ago that there are few things more dangerous than going to the scene of a domestic violence call, or even a simple traffic stop. And I had a very good friend one time who was making a simple traffic stop on the freeway, and he had just an odd hunch or feeling that something wasn't quite right. So he approached this traffic stop in a very careful, much more cautious way than he ever would have. He called for backup right away. Something his spidey sense was going off. The gentleman behind the wheel had secreted a weapon, and his objective was to blow away the police officer. There was a kidnapped victim in the trunk of the car. Traffic stops, domestic violence matters, simple. What you might think is the average call, in very short order, turns into a dramatic, dynamic, life and death situation, and you're asked to make decisions in a microsecond that will affect the universe of families, your own and others, as a result. It's probably the toughest job in the world. So, in that context, our objective is to come up with a resolution, and this is kind of a historic moment, the first union contract in the history of Pembroke Park, Florida, and make it one that treats our officers with dignity and respect. And I'll say one other thing. This contract, no contract covers all circumstances and all possibilities. So rest assured that when these negotiations are complete, and hopefully we received approval from the commission, which is our legislative body, we will reach the point where we continue to operate and cooperate with the chief's office that solves issues and answers problems that aren't even contemplated in the contract, that keeps the morale and the approach towards your job as a police officer on the very highest level. Police work is tough work. We all know that. But if we can provide as much of a positive feeling about your work environment here as possible, it's better for all of us. And so, in other words, we appreciate you. Be patient with us as we go through this process. Obviously, we're not going to resolve things in this one meeting today, but this does not need to be a process that's filled with animosity, because we want to give you as much as we can give you without endangering what the finance director believes might be something that makes it difficult for us to continue to do things on a long-term basis. But we're going to give, and so my approach has always been, when you find different elements, and the cost element to it is relatively low, with the blessing of the chief, we want to say yes as much as possible. You're protecting our families, you're protecting my family. So, having said that, I know that Lorena has sort of a process she wants to follow through here, along with the guidance of our town attorney. But we appreciate you, and thank you so much for your patience as we go through the process.
I just want to add, for the FOP's point of view, I'm really glad to hear that, because right there, that tells me that you guys are willing to work with us and you value what we do out in the streets every day. So
Yeah.
I'm looking forward to this.
You are number one.
Thank you for that, Mr. Lynch, and for setting the tone
Sure.
for our meetings, this meeting, our first meeting, and our prospective meetings.
Sure.
So, if we're ready to begin, unless you've got any other,
No, I think we're ready to go.
remarks? Okay,
Yep.
thank you. As I said, this is our first meeting, so we did receive, 34 articles, prepared by the union on September 4th. And what we're gonna be discussing today are the town's response, to the FOP's, articles. We also wanna acknowledge that we understand you've provided a wage proposal with respect to some of the officers in your unit, okay?
Yeah, that was just a proposal back then, but fortunately, we've had more contracts that have been approved over the last couple months, and the numbers are gonna have to be adjusted.
Well, so if
We'll
I
get to that.
understand you're withdrawing that proposal, then we
Yeah.
can wait to receive
Yeah.
a future proposal,
That's fine.
complete for the unit,
Yeah.
right? One of my questions today was, well, what is your proposal for lieutenants?
Right.
Okay, all right, well, we understand that, we will expect a new proposal from the union. All right, so, I am old school. And I learned from an old schooler, so here, let me distribute these copies for you. Let me begin by Article 1. Not 4, no? I made extras. You guys need copies? I brought you copies.
Is that consistent with
Yes.
this? Okay, well, make sure the chief gets one.
Yes. Excuse me. Chief?
copies?
No, I have enough there.
I don't think that was one that went to Jason.
I gave him two.
Oh, okay, all right, very good.
All right. So we in essence agree with your proposal with the exception of the language in section 3. Our counter proposal would just be to strike that provision. It relates to processes that are delineated in the law, and it talks about prospective clarifications or clarifications to the unit. I mean, the unit is formed, the contract impacts the current unit, and we just don't see a need to provide for that there.
So you're basically saying that the contract speaks for itself, is what you're saying?
Well, this
Yeah.
doesn't even speak to the unit within the contract, right? It talks about prospectively, if we were to amend the definition of the bargaining unit, you would have an opportunity to intervene. I think you'd actually be a party. And just to understand the process, I don't mind taking questions.
Sure.
Or I could just go over
Yeah,
all the
yeah,
proposals, you
yeah.
can caucus and get back to me?
Yeah, yeah.
Okay?
Yeah, I think, questions back and forth, I have no
Okay.
issues with that.
All right. So if there's no further discussion on that, let me give you Article 2.
By the way, Mr. Maniotis, you should understand, this is not a speak now, forever hold your peace kind of a situation. So, Lori may have identified something that she's moving on to another section, but
Yeah.
you have reserved your right to hear these issues later on.
So again, in number 2, we agree to your language with equivalent reservation of right at the bottom.
So you said you want to take that out?
No, we're proposing to add language.
Oh, okay.
Last sentence.
Yes, in the last sentence.
Underline is an addition, strike through is a deletion.
Right, no, I know, but I have it in here already.
No, you have the
Oh, you have
union.
that below.
You have the union. They added the town manager, right?
Yeah.
Yeah. So we had nothing shall be a waiver of the union's rights, and they added
You can
nothing.
double
Okay.
stamp both parties.
Gotcha. Okay.
Here's Article 3. There's only 2 proposed changes in this article, and they both reflect what the law says with respect to strikes. In Article 1, it just talks about the town's ability to resort to court and seek equitable remedy. And then our Section 2 is just an updated definition of the term strike. It's verbatim what's provided in the statute. Next is Article 5. Really, these are just clarifying provisions. You had layoff in subsection C. We've relocated it to subsection E and just expanded that. And then on the second page, we've reworded that as well with respect to declared emergencies.
Little language cleanup. Right? Thank you.
we did was just liberalize the process. We really didn't need a written list of who you've designated as bargaining representatives. We just thought that you could let us know within 72 hours in writing to the chief, to the department.
Okay, you skipped Article 6.
Yep. I don't have an answer on that just yet.
Okay.
4 or 6.
All right.
And finally, there's another change on subsection G and I, and it's just expanding the means or channels of communication that are prohibited for solicitation. Just clarified at the bottom of Article 8, Section 3, that, either party may find something objectionable and they can negotiate as to what the issue is with respect to the use of bulletin boards.
Chief, do we have a bulletin board somewhere?
We're gonna have to put one up in the squad room is where we're gonna put it, so.
Yeah,
We were
okay.
literally just talking about that the other day. We have somewhat of a board in there, but it's got some other stuff on it, it's kind of multi-purpose, this designates their own board.
Sure. I don't think I've seen a union contract that negotiates the content of bulletin boards. I guess I'm impressed that we're at that micro level, but,
We gotta make sure our members are able to get the information.
yeah,
you know,
right,
so.
And we're old school, I guess.
Standard normally.
sure, okay.
Okay, so that's no problem. Oh, dues deduction, nothing there?
Not yet.
Oh,
Not yet.
Nothing, okay. Oh, one more for,
Oh.
one more. Yeah, yeah.
Oh, we're good.
Oh, we got it,
Yeah.
okay.
So the town, understands that it's got an obligation under federal employment laws not to discriminate for any protected status or disability. We just propose in section 1 to strike out the language that, seems to create a guarantee or an assurance that the work environment will be free from discrimination. And then in section 3.1, there's just a recognition that the contract article doesn't create any greater rights than what the employee would have under federal law. It also proposes to eliminate the union's participation in any consent agreement related to the town. And also proposes to eliminate the section in, section 6 in its entirety related to affirmative action.
Lorena, on that section 5, crossed out, union shall be included in negotiations in future consent decrees which reflect the union and its members. But if they've got a contract and we're in front of a federal judge, we're about to sign a consent decree, we're still bound by the terms of this contract though. So in a sense, even though you're striking this out, seems to me, I'm guessing lawyers, you can tell me otherwise, that we still have an obligation to adhere to the terms of this contract, and we can't sign a consent decree with a judge out there somewhere which obviates an element of this contract. Is that a fair statement?
I think that would be generally fair, but the language that's being proposed to be stricken is a right to participate in the negotiation or content of that consent agreement.
Okay, I understand. No, there's the distinction is that they may not have the right to participate in negotiate that consent agreement, but that doesn't take away our obligation to go back to them and adhere to the terms of the
And
contract.
we would be limited in what we can negotiate, because we wouldn't negotiate around the terms of an agreement.
Right, right, okay, all right.
So,
Right, it's one more.
One
Oh,
more.
I got it, I'm sorry, I got it. Yep.
in Article 11,
Oh, boy.
the town recognizes that it's got an obligation to its officers to follow the Law Enforcement Bill of Rights. And so it's incorporated by reference by citation to the statute here. The remaining sections just recite what the law already provides. What's significant in the language that the city is proposing is that the employees who have a claim for a violation of their rights under the Law Enforcement and Correctional Officers Bill of Rights or Act, that they pursue the remedies provided in the statute and not a contractual grievance.
Some of the issues that we deal with 112 in particular, the remedy for, like, say we think there's a Garrity violation, and you know, you guys call X amount of people, we call X amount of people, there's no remedy after that board that gets paneled that says, yes, there was or wasn't a violation. When the statute got updated, you know, whatever, so years ago, they removed, trying to think of the terminology, the petitions to go to the judge.
Review?
No, it was at the end of the statute originally, and they revised it and they screwed it up. They basically, it's an incomplete thought, essentially, if you read it in its entirety. So that was just my concern, looking at this, because, yes, 112 has all these in there, except for the remedy portion, it's an incomplete thought, if you actually read the statute in its entirety.
So, I understand the position. We will consider that and get back to you on this article. But this is our proposal for now.
Ray, is there anything that you crossed out that is not included in 112?
No.
Okay,
I'm sorry, it's injunctive relief, it's not in 112. That was the issue, it used to be. And then when lawmakers tried to revamp it, somehow got stricken out.
Thank you for that. So our position in terms of subcontracting is that it's a management right, and we just disagree with the premise that the officers would have a right to receive notice and a right to participate as a matter of contract right in the public hearing and the public deliberation over subcontracting. You certainly have a right to participate in public discourse at a public hearing as a member of the union or as a member of the public, but not as a matter of a contract right. I also wanted to point out that we're proposing to strike out section 4, where there was a reference to layoff procedure. There was no corresponding procedure provided in the proposals. And so we,
I'm sorry, Article 13,
No
nothing for that right now?
no response on that just yet. So with respect to discipline and discharge, we agree with what you,
I'm sorry, Article 14?
nothing yet on
No,
that.
no. I'll make sure we get all that. Okay, thank you.
Right, so in Article 15, we agree with the concept that you've proposed. We made a couple of changes. One, I didn't know what, or we didn't know, I should say, what the references under Section 1, 2, 3, and 4 meant. But we just generally recognized in Section 1, in the proposed addition, that the town has the right to impose discipline, and that it should be pursuant to this article. The concepts that you've laid out are essentially acceptable to the town in terms of the number of working days, the notice required. We just replaced it with the current name of the notice. For example, in Section 2, it's a PIP, right, or a Notice of Improvement Action Plan. And we said letters of counseling and a PIP is not discipline, it's not grievable. We accepted your provision with respect to Section 3 on those restrictions on those privileges that you identified. So that's all original language. In Section 4, we did say that written reprimands were not grievable, but that the employee would have a right to submit a rebuttal, which would be kept together with the grievance. And then, you know, they're just different changes to the pre-disciplinary procedure as you've laid it out, but it substantively remains intact.
Let's go back real quick with the Section 1. Explain to me why you crossed out 1, 2, 3, and 4 again.
Well, contextually, it didn't make any sense. There was no reference in the text to what 1, 2, 3, and 4 meant. I understood that it's probably type of discipline, but rather than limited to the type of discipline, it's just generally the town can impose discipline. Clearly, we understand that generally the type of discipline is an oral counseling. Well, we've said it, or letter counseling is not a discipline, right?
A progressive discipline is what we're kind of getting at with that.
Well, I don't know that you propose progressive discipline in this article.
We can clean it up.
So,
Yeah, there's no preceding language to those 4 items that says, we prefer progressive discipline at these levels,
Right.
progressively. It doesn't say that, it's just sort of stuck in there.
That's fine, we can go over that. Okay.
those are one-pagers. With respect to information requests, you know, we understand that as part of bargaining, you will have a right to request information, but outside of bargaining, you would be treated like any other member of the public in terms of accessing the city's public records. And you've provided as much in Section 1 that you would want to receive to the same extent that the public receives these notices by the town. Knowledge that access to any other record is provided by Chapter 119. A procedure about, you know, having the right under 119 to charge a special, I think it's called a special charge for excessive information technology resources. And to the extent that the town already has an existing policy, then we propose that we follow the town's policies with respect to public records.
Article 17 transfers.
Nope. We're on 25.
I know that. Just asking you if you have anything.
I'm a little bit confused. If something's underlined, it means it's new, does it not?
Yes,
So 17 is new, is it not?
we don't have that proposal just yet, so
Okay.
we're on 25.
Gotcha.
Now, moving on.
Yes.
Court appearances, just for the record, nothing on court appearances, correct?
Not yet.
Okay.
So 17 through 24 are pending with the town.
For now.
Thank you.
So the grievance article is in its entirety
I'm sorry,
most,
hang on one second. I gotta follow myself here. Okay,
the grievance article is essentially acceptable to the town, with the exception of the additions proposed in section 1 and section 2, and the strikeout in section 3. And then just some syntax in step 3.
What's the length of probationary period, chief?
1 year.
Okay.
This is the next one. So in arbitration, you know, this is just a proper reference in section 1, and in section 2, we propose that instead of tossing a coin, it's just the person requesting arbitration who gets to strike first. And then just talks about certain limitations on the arbitrator's power to exceed the provisions of the contract. And you'll find that in section 3.3 and 3.6. Section 3.9 is proposed to be stricken, but the standard is preserved. I'm certain the proposed preponderance of the evidence just the same. Right in 3.6. And the final strikeout is section, new section 4.
I'm sorry, you're getting rid of section 4 altogether, or? Cause I just see a strikeout of section 4.
4.0.
But then the rest of it.
Right, because we propose to strike out 3.9, and just to keep the sequencing in number,
Got it, okay.
then that language would become 3.9, and instead of it being 4.1, it now becomes 4.0.
Okay,
Just the
so the
sequencing in number.
numeration is all that's, okay.
With respect to what your proposed 4.0,
it.
right? Then there's a strikeout in your proposed 4.1.
Got it.
Lauren, you're making a lot of handouts, and, which is one way of doing this, but I'm presuming at the conclusion of this today, you can send a digital copy
Yes.
of everything, so you can just throw all that away, and you've got it all in one place instead of organizing your little sections that you're handing out, yes?
Yes, and I think that we could probably, you know, work on renumbering and an index at the end to kind of just encapsulate the whole agreement, but we're just beginning, they
By the way, the
proposed.
next time we have a session, since you can do this digitally, and I just happen to notice we have this great technology, can you interface with the people from the city, so when you have these sessions, we can actually look it up on the screens if we want to as you go through it?
I don't know the town's capacity, but I
We
thought
have
the
that.
IT
It's-
director
we have
was
that
here.
capacity.
That would,
No, we
that
have
would
that capacity.
certainly facilitate the discussions, I would think.
No, we got the capacity.
Thank you.
We'll coordinate it.
Coordinate
Yeah.
that for next meeting, to avoid the paper.
You're working though, we're good.
Some of us are old school.
I'll pay for it.
I like where you're thinking.
I know we have a lot.
Less paper.
Let's,
It saves
let's
trees.
limit the trees that we're gonna be
Yeah.
killing.
She did say she was old school, so.
Yeah. Four there.
Alright, so we skipped 27,
Yep, we're on 30.
skipped 28. Great. You got 30, right?
Yeah.
Okay. Carl.
So we just wanted recognition that there's two sets of policies, department policies, and then there are town policies. Department policies are what you proposed in section 1. We mimic the language in section 2, and in section 3, we provide for the primacy of the contract if there's a conflict between department policies and the town handbook. The terms of the agreement would govern, which is
The CBA, yeah.
right, what you had provided. We just added the distinction there between town or department rules, regulations, policies, and procedures. And we propose to strike out section 3.
What was the reason for striking out section 3?
Well, I think that you preserved in a prior article, I think it was maybe recognition, I can't recall the specific article, but it's where we made the equivalent reservation of a right. You're not waiving a right to bargain over mandatory subjects of bargaining, and we're not waiving any right of management. You do? Sorry.
Article 31's pending with
Yes.
you guys. Use of force.
I'll get to some of those articles after.
Oh yeah, I'm no rush on this.
So with respect to Article 32, we propose to strike out Section 1. I think it's a prerogative of the department and the town to determine what their personnel records are made up of. And the same thing for Section 2. Your proposed Section 2 would now become Section 1, and we've added that provision to give you a right of access on your own time, as you would were you making a public records request. And we've kept your proposals with respect to the expiration of the reliance upon written reprimands or letters of counseling for, and here's progressive discipline. See that on section 6? But I think, probably needs to be addressed in the prior article. I wanted to ask you, with respect to your preamble, there was a reference to a town ordinance. Can you explain what you mean by that incorporation? We weren't certain about what that reference was intended.
Let's see.
So, that's the reason why it's proposed to be stricken, but otherwise the preamble is acceptable.
Well, I'm sure that was probably from another contract that we put the language in, so I'm sure that's what it is.
So we propose to strike that language.
Let's take a look at that.
So for now, those are the only counter proposals we have. We do have some acceptance, and that would be Article 6. We can TA on Article 6 as proposed by the union.
Yay.
And we have no objection to your proposed Article 9 on dues deductions. So we can TA on that language as proposed by the union.
Good?
Yes?
You don't want to TA any more?
No, but I do have a question that I need to ask you.
Okay.
We're gonna give you a stamp, and you get 3 for free.
Okay.
Well, let's sneak in the pay thing then.
All right. What's your question?
In your seniority article, Article 24.
Okay.
Can you explain what you mean in section 2A1?
I'm sorry, section 2A1.
Chiefs, do you have that article?
I don't have that file.
It's seniority A1.
Brian, do you,
Yeah, I think it's just basically sounds like it's defining what we would consider a vacation under when the officers go to pick their vacation time,
It's vacation pick.
it would be what their vacation pick would be. So if I try to put in for 3 days off, that's not considered a vacation request, even though I'm using vacation days. A vacation request for the purpose of seniority would be like, I'm taking a week off for summer for my kids. And they're just basically defining what a vacation request would be.
So,
Not just a regular day off here and there, a couple days off here and there. A vacation request would be at least 34 and a half or more hours of block at that one time. And that would be considered their annual leave time, which is what me and another officer put in for the same time. And seniority would basically dictate that I would get it over this other officer if I was senior to them, if we put in for the same time. I mean, Paul and I came from a 500-man department, and very rarely did it ever overlap, but sometimes it does. And so there was some delineation between who would get the rights to that vacation if our manpower would not allow both of us to be off.
I think I understand the concept of, thank you, Sergeant, of seniority. I was wondering just, now you've explained that it's gonna be in blocks of 34 and a half, but my question is, if you work shifts and 3 days are 36 hours, so I'm shy of 3 days here, so it's not it doesn't
Like I see what you're
correlate with the example that you've given, so, the town has a question about that proposal.
So that would probably have to adjust the hour that would define annual leave.
We would ask the
Based
union
upon our
Yeah.
to repropose,
pay period, okay.
okay?
Thank you for that.
Can I have a chance to caucus?
Yeah, we were gonna do the same thing.
Okay.
You want us to stay here?
You wanna step
We can step out.
There's actually a small conference room right to the left,
We
and
can
since
set
our
up.
group is smaller, why don't we vacate, you guys
Yeah,
stay
you
here?
guys relax.
So it is 10:16, and we will stop the recording.
Can I rush past you and use the restroom?
Thank you.
James, you should join us.
Bathrooms are for closers.
Just sprinkles.
I think that moves up a lot.
We'll comment for a second until the recording stops.
Yeah, that's telling them.
Thank you very much. awkward silence for a second.
The audio is recording, I'm just waiting for the video to load up.
Okay.
All right.
It's now 11:13 and we've returned from caucus.
Okay. Okay, we can TA a couple right off the bat here. We got 4 that we can TA. We're gonna TA the preamble. Like to TA Article 2, non-discrimination. We agree with that one, with you? Article 5, management rights. Agree the language on that. Article 8, bulletin board. We're gonna close that, do that. And we have some discussion on 2, Article 7, FOP representation. Tell me when you have that in front of you, when you're ready.
We are.
Okay. And our district director is gonna comment reference to the 120 hours that you have down here. If you wanna make a comment on the conferences.
Sorry, we're starting on 7.
Yeah, 7, section D. So no, yeah, section 1D, I'm sorry.
Yes?
It says for 120 hours for the FOP shall be awarded 120 hours for per person during work hours. To kind of give you a caveat, the FOP for the president himself is required to go to 3 conferences throughout the year, which is 40 hours each of his own time, as well as every president should attend every city commission meeting to make sure they're always up in what's going on. And I can tell you this from Hollywood, because I work for the city of Hollywood. I am at every commission meeting because at some point, at some time, even if it has nothing to do with police, somehow I get tapped for a question about union stance, whether it be through a commissioner, city manager, or the mayor himself. So our request is to bump that to 240 hours. Now, Hollywood has 700 hours. I'm not asking for that. That's not reasonable for here in a town this small. But for what he's gonna have to do on his off time, I think that's very reasonable.
Like right now.
And then also, there was a typo. It's same section down to, it says, town agrees that designated representative of FOP shall be allowed up to 100, but it's spelled out 100, but then it says 80 in numerical. Where's,
So what's the correct number?
D.
No, what's the correct number, 100 or 800?
yeah, 100. We just want to
okay.
make sure it's with a typo. We're good with the 100.
What's the number you're asking for?
Above?
120, yeah.
Yeah, it's a 240.
In section I.
And if we can come to an agreement on that.
Wait,
we
there's
can
one more
Hold on,
part
sorry.
of section.
And then and then the very last page of I, solicitation of membership. Now, under this section, it says solicitation of any kinds for the FOP, including the membership. If we could strike out solicitation of membership, but keep everything else, we'd be good with that. And the reason why is 9 times out of 10, when you have a new hire come in, every FOP goes into their, whether it's a new officer or a seasoned officer that you guys are getting, to sign them up for the union. And the reason why we do that is because not just for fighting against the city or town, it's for the criminal aspect. So when officers get into officer-involved shootings, they need to have a criminal defense lawyer right then and there come to their aid. If they're not, because we miss them, because half the time, if he's working with night shift and new guys are here during the day, he might miss that opportunity to connect with them and sign them up. So therefore, if they do get into some kind of skirmish, then all of a sudden now you have an officer that's not properly represented out there for 9 times out of 10 it's gonna be justified, but for the criminal matter. So I think it's a bad stance to have that in there, especially with the relationship that you guys have. It's good to have your employees covered, whether it's be through the city or through the union. It's a one less thing to get off of your plate, and you can put on ours.
So which phrase do you want out? Which
So
do you want in?
it says including solicitation of membership. Now, solicitation of any kind, meaning like political stuff,
So you want
absolutely
that phrase in or out?
out.
Okay.
to allow those
So
guys
you'd
to,
want to include the collection of FOP monies?
That's okay for us to not do. In
Yeah.
other words, all we're saying is we would like the ability to speak to the new hires.
So you want to keep solicitation
No.
of membership in?
It's saying it's not allowed. That whole section.
yeah, it
is
says
saying
during
it's not
work
allowed.
hours. It's not allowed during work hours.
So we're
Read me the
just-
sentence as you
Okay.
wanted to read.
So right now it states solicitation of any kind, any and all kinds by the FOP, including solicitation of membership, the collection of FOP monies shall not be engaged during work hours. So we're asking is solicitation of any kind by the FOP, including the collection of FOP monies shall not be engaged during work hours, but with the exception, or have an exception clause in there of, having members join.
Well, why don't we, consider the law in terms of what the prohibition on solicitation on town property is and during work hours? Language, but we understand that what you want is access to the new, recruits.
Correct.
To provide them information about the union,
Right.
not necessarily to
They don't sign up right then and there, we just give them the information and they sign up on their own whenever they want.
give a chance to
Yeah.
craft
Right, the
something.
Yeah,
accessibility.
it sounds reasonable, by the way.
Unless you wanna craft something and propose.
I can, that's fine, yeah.
We understand, your comments and how you want to modify your proposal, and we'll get back to you in terms of the time.
Perfect.
And if you can provide us that language, then we'll have a response for you.
Perfect.
Did you also say you had comments on two?
There's two articles, there's another one,
Oh,
yeah, so sorry.
The next one is 25.
Ellie, what was the,
It was the probationary employee.
Oh, yes, the only thing that our concern was, Article 25, Section 3. Let me know when you're ready. Probationary employee shall have rights in the grievance procedure, but shall not be entitled to grievance disciplinary. You struck out have rights in the grievance procedure. Our stance would be, you have, well, how many guys you have here on probation?
I would say probably close to 4 or 5, at least.
So that's half, almost half your department's on probation.
We'll have 5 on probation. here,
Would the
which
city,
is-
be willing to agree to allow them to grieve to the chief of police on grievance matters and stopping it there? And the reason why I say that is because, again, I know this town's very small and it's hard to keep cops here, you know, especially with other cities are giving out some crazy benefits. But to kind of have that at least protection from both parties, that, hey, we know that as your probationary officer, because half the staff is, that we're not gonna just throw you to the wayside. There's some kind of remedy, and I'm from understanding.
With
from
him
talking-
having final authority?
Yes.
Right, exactly.
What if he's the initiator of the disciplinary action?
Then go to the city manager. Just one step up from, so like I
You have to
said,
think about
Yeah.
this, chief, because he's on probation, so.
that's a thing, you know, but you bring talent here, from what I understand, is you bring seasoned chiefs and officers here. So I think you're allowing them to make their decisions and giving them that right to do so. But again, half your department's on probation.
Well, it's something to look at, right, what the status of the employees are, whether, how long they've been on probation and what the
Right,
status
the
of
biggest thing you
employee.
don't wanna turn into, and it's very easy to here, I call it a gypsy police department, where guys will come here just to get certified and leave. Because there's no buy-in from the police officer to stay. You know, and our example from Hollywood, because that's where I work at. We're not the highest paying police department, but our relationships with our command staff, our city officials, and our city managers, everybody's invested. And as long as everybody's moving the pendulum in a direction, now, we might not all agree on some points, and that's okay. That's what kind of these topics are. But to have that hardened base that you're showing police officers that you truly do care, and not like, well, we're gonna fire you, toodaloo, you know, or just some kind of remedy.
And may I add to that as well, you know, with having 4 or 5, whatever it's gonna be out on probation, one incident could cripple this organization. And it could be a completely justified incident. You know, officers could be involved in an incident with a use of force and be totally justified, but because they're on probation, are we going to dismiss them because of a technicality that they're on probation? Whereas we have seasoned officers who've been involved in uses of force in their career, and they understand what goes on in those processes. So that's kind of what we're trying to protect, not the person that messes up and doesn't need to be here. We're not talking about that. We're talking about allowing them, with their vast experience, to make that judgment call. And of course, step two is the deputy chief. So we've got processes in place here, but we're just trying to give them that reassurance that we're not gonna just toss you to the wayside because you're on probation.
Why don't we do
Hope
this,
you get through it.
let's, let me have an opportunity to talk to the chief and
Right.
to
Okay.
Jason about that, so I can get a sense of how they wanna proceed that regard. I just had one question for you that goes back to the 120 hours.
Yes.
You intentionally want, because I've seen you at these commission meetings, do you wanna go to more commission meetings? This is an intentional desire on your part?
Sir, I just,
Yeah, so it's
Oh, I
like,
see.
yeah, the time bank is not automatic, so for like Hollywood, we have
Okay.
700 hours. We don't use all of it, but we get to around 600 mark. Because 9 times out of 10, if I have to work this or that, and then all of a sudden I have to attend a commission meeting or attend this or attend that, and the way the FOP kind of runs is that relationship bond to have with the city and the union itself. It's not very, it's never gonna have this animosity if everybody, like I said, is on the same page.
and I've been fortunate enough to have a pretty lengthy career, and Paul's kind of been a mentor to me for many years, and to see having somebody in your corner, and it doesn't always mean you fight when you're wrong, it just means that the due process is in place, and some of these guys don't have that experience, and they don't have anyone to look forward to look for help, and just, Paul and others, they've been a pretty good mentor to me, so I'd like to pay that forward to some of our guys, to your point about, I have 4 kids, man, I don't wanna be here all the time, but it means a lot to our guys, it really does.
And it does cut down a lot on the whole grievance issues and all stuff, because the union member can be around more. They're not here on their personal time. Now there's like the whole question of, well, do I want to come in or not? It allows them, it gives, whether it's him or the next guy that's sitting in his seat, or a girl, the leeway to move and be flexible, but still balancing that work-life atmosphere, so.
These are hours that are not accrued and carried over.
No,
These
no,
are
they cap,
used
and then
or
if you lose it or
lose
lose it, they're not, you can't sell them back, none of that BS. It's strictly for union business. And if, like I said, if some years you don't have a lot of union business, and you don't hit them, and you just lose it, and it just restocks. Other years, you'll be using it all nonstop.
And question, how do they roll over? Is it calendar year or?
No, it's not, it all depends on you guys. We do, a fiscal year.
Fiscal year?
October 1, or September 31st, or whatever it is, but they don't roll over. It's capped, and if you die, it dies, and it just gets restocked the next year.
I think that's it on our part, right?
And everything else is gonna be pulled.
Anything you wanted to?
No, we have the remaining, articles that you proposed, we're gonna hold them and get back to you at the next session, if that's okay. Yeah.
Thank you.
Okay.
Okay, so I think, we're ready to adjourn at this moment.
Yeah, why don't we, while we're on record, why don't we, pick a date? Can we do that?
We discussed that, but I think we were gonna have to suggest
Okay.
dates. There's some people that need to check their calendars and do not
That's
have the
fine.
ability to do that. Thank you.
Thank you so much.
Thanks.
So how's that gonna
Do you
happen?
wanna send Lorena some date options and y'all coordinate and we'll go from there?
And what kind of range are you talking about in terms of how much additional time before we convene again?
I think we could do this for the next 2 weeks, maybe even less.
That's why I suggest you all first time, because we have some calendars
Yeah.
to coordinate.
Mm-hmm.
Yeah, we're gonna need a little bit more than that, just so you know. Okay,
All right.
all right, thanks.
Sounds good. Thank you.
11:27 and we've adjourned.
Thanks, John.
Have a great day.
Have a great week.
Good night, everybody.
Yes, of course.
Thank you.
I'll be back. Good to
Hey,
meet you
nice to meet you.
guys.
Thank you so much. Appreciate it.
Hey, Paul, good to see you, man. Thank you.
Oh, yeah.
Thank you.
Oh, I bought a scout.
Good to meet you.